we're going to have some comments now about medical marijuana, both from the insurance side of things and in the employment environment. So I'll be curious to see what happens. Anthony Bowser is part of our employment law section at Thomas and Hafer and deals exclusively in that arena, but he always admires the intellectual intensity of workers' compensation. And Jamie DeSisto is from the Baltimore office and has studied this issue for some reason. She's very, very interested in this topic. And she's going to talk about at least one of the things, a national case that was very scholarly treatment of the various issues that can arise. And Justin Beck has written a very, very thorough analysis of issues that do arise. If you find where Dr. Santos' slides in the big book ended, Anthony has a 2-page outline. Then there's a case from the state of Maine, which is a topic point. Justin's article follows that, and then there's a copy of the Pennsylvania Medical Marijuana Act. After that, we'll do a little bit of case update from jurisdictions Maryland and New Jersey, where we have more and more cases as the years go on. And so Anthony will lead us off.
Thank you, Gene. When the Pennsylvania Medical Marijuana Act was enacted, I started getting a lot of questions from my clients who had over the years developed employment policies that prohibited the use of drugs in the workplace and had made efforts to alleviate use of drugs in the workplace. And there was this kind of sky is falling mentality about, what are we going to do now? Now I'm going to have all of my employees coming in stoned and just saying, hey, I've got a medical marijuana card. So we took a look at the act. Unfortunately, there haven't really been any cases in Pennsylvania yet to deal with this, but there has been a recent case in Connecticut that has shed some light on the topic. But why don't we just kind of roll through some of the protections first. So the Act itself contains some pretty specific anti-discrimination provisions. These anti-discrimination provisions are similar to the other types of state and federal statutes we have which prohibit discrimination in the workplace. It essentially requires that you cannot take action against an employee solely on the basis of the employee's status as a certified medical marijuana user. When we first took a look at the Act, that language I thought was unique. It says solely on the basis of the employee's status. One of the avenues we initially took to try to combat employee use was the idea that, well, what if we refuse to hire somebody because they've failed a test? We're not refusing to hire them because of their status, but because they've taken a drug test and they failed, or we terminate somebody because they failed a drug test. Would that be sufficient? I reached out. My first presentation on this was with one of the authors of the Act, the chief counsel for the Republican caucus, and she was one of the authors. And she actually indicated that was something they left in the Act for that very reason, that they wanted to leave this intentionally vague so that the courts could sort that out. And so initially, at least, that's one of the avenues that we might want to consider in approaching that employee issue. The Act contains some protections, I believe, for employers. You're not, under the Act, required to allow employees to use medical marijuana on your premises. You also don't have to allow them to be under the influence of medical marijuana when they're working. Notably, however, there's no definition of under the influence in the Act. And so, again, that's one of these gray areas that the legislature left open. We're still not sure how to define that. Does that mean if there's still something in their system from their use the night before, are they under the influence or not? We don't really have any clear guidance on that issue yet. Another nugget I think the legislature threw to the employers on this was that they indicated in express language that an employer is not required to violate federal law. As we all know, marijuana, even medical marijuana, is still illegal under federal law. And so, again, this appears, at least on the face of the statute, to be a protection for employers so they can try to enforce drug use policies and say, look, I'm not allowing my employees to violate federal law. I'm not violating federal law, so maybe it's okay to dismiss somebody who is a medical marijuana user. There are also some specific provisions in the Act that deal with particular professions. Employees who use high voltage electricity or other public utilities cannot have more than 10 nanograms of active THC per milliliter of blood in their serum. If you can find a test that is that specific, please let me know. To my knowledge, there's not one out there that can identify that to that level of specificity. However, there is a provision in the Act restricting that use. Also, heights and confined spaces fall under that same definition. There's also a general prohibition where if you have employees who work in dangerous, life-threatening situations, you can prohibit the patient from working in those situations if they are a user, and that prohibition on the employees is not deemed to be an adverse action under those employee protections. So, as I mentioned, we have this act, and we can look at all the statutory language, and we still don't really know how it's going to pan out. Very recently, we had a decision from a federal district court in Connecticut. This was an important decision, because, at least here in Pennsylvania, because the Connecticut medical marijuana law, theirs is called PUMA, the Palliative Use of Marijuana Act. The PUMA has very similar language to the Pennsylvania Act. It's almost identical to the Pennsylvania Medical Marijuana Act. And so this case is probably the first one that gives us some real guidance. Unfortunately, I think it panned out in favor of the employee and gives the employee a number of rights that restrict the employer's ability to enforce their drug use policies. In this Knopfsinger case, the employer was a federal contractor. They hired an employee on a conditional offer of employment, subject to the employee passing a drug screening. The employee immediately informed the hiring manager that she was a certified medical marijuana user, showed her the empty pill bottle with the dosage and everything on it, and indicated that she uses the pills every night to treat her PTSD and night tremors. The employer went forward with the drug screening, which of course came back positive for THC, and refused to hire the employee, and told her that it was because they follow federal law, and federal law says marijuana is illegal. Employee files suit, and the employer filed a motion to dismiss the case at the very outset. The court denied the motion to dismiss. The employer raised two main arguments at the motion to dismiss stage. First, they said that the act did not give a private right of action to employees who were terminated because it didn't expressly state so in the act. And then they also argued that that firing or refusing to hire qualified medical marijuana patients, even if they test positive on a drug test, is preempted by federal law. The court rejected both of those arguments. The court said that even though it doesn't expressly state there's a private right of action, by including those anti-discrimination provisions in the act, they clearly intended to give a right to employees. Also, they said that the law was not expressly preempted by federal law making marijuana illegal. Case moves forward into discovery. At summary judgment, the employer then argued that the same argument that I outlined at the beginning when looking at the anti-discrimination statutes, that they didn't fire the employee just on the basis that she was a certified user, but they fired her for the positive test. The court rejected that one and said, look, if that were the conclusion we reach, there would be no basis for the anti-discrimination provision. Because if somebody's a certified user, of course they're going to test positive on the test, so that would render that whole provision a nullity. And so the court allowed the claim to move forward, denied the employer's motion for summary judgment. There's some key takeaways from this, I think, and briefly as well, the employer also argued in summary judgment that because they are a federal contractor subject to the Drug-Free Workplace Act, that they have a right to enforce their policy. The court rejected that as well, saying that the Drug-Free Workplace Act does not actually require drug testing and does not regulate the employee use of drugs. It just says you have to make efforts to try to not have employees under use of drugs at work. It doesn't do anything as far as off-duty conduct of employees. So again, a couple of key takeaways from this. I think if you have a zero tolerance drug policy, especially with pre-employment screening, you've got to make some exceptions to this. You may want to look at revising your policy to specifically note that exceptions will be made for those who are certified as medical marijuana users under the Pennsylvania law. Also, the law does not prohibit you from enforcing off-duty policies or off-duty drug use policies or other types of drug policies. As far as disability accommodations, this act does not specifically, I think, inhibit your ability to engage in the interactive process to determine if reasonable accommodations are available. You should, I believe, still, if an employee has a disability, comes to you and says, I need to use the medical marijuana as a disability, treat it as you would any other disability and make accommodations where available.
Good morning. Anthony, one thing that came up at our Maryland Workers' Compensation Conference was the discussion of the sort of the problems between the federal compliance and state compliance, that, you know, the dichotomy that we have with marijuana being illegal under federal law, and specifically in relationship to positions such as truck drivers, folks that have to get CDL licenses, complying with OSHA, all these federal regulations that some of these employers deal with every day, and how that they cannot make exceptions to their drug policy under the federal law for those types of positions, mainly for safety reasons, which is why they're in place. How do you suggest that those employers address that?
Yeah, I would still say for those with federally regulated industries like truck drivers, there's nothing in these state laws that would preempt those prohibitions under federal law. For DOT drivers, there are very specific provisions that they cannot use marijuana. It's still illegal at the federal level. And so under those circumstances, I would still suggest that if you're enforcing those policies, that in that case, you're okay to continue to do so.
Thank you. I'm moving on to Justin and I are kind of dealing with, just from a practical standpoint as an employer and insurer, handling workers' compensation claims in the currently unsettled legal environment that we live in with medical marijuana. What are the likely defenses that you may have coming, and what has been argued in other states successfully? I would say for Maryland, we do not have any specific comment from our courts yet on how the courts are going to treat payment for or reimbursement for medical marijuana under the Workers' Compensation Act, and that's something we're waiting to hear about. It has been addressed in other states. We do have medical marijuana in Maryland it's now legal, but certainly marijuana in general is not legalized in the state, so we're similar to Pennsylvania in that way. And we're also have a statute that's not quite as detailed as Pennsylvania, but has a similar carding system where the doctors do not prescribe but recommend or that they are available for the card, and then the patients are left on their own to find out what products may be available to them at the local dispensary. I'm going to be talking about a Maine Supreme Court case that just came out in June of 2018. And specifically, this is a very long decision, and I'm not going to go into it ad nauseum, but what it is greatly educational about this case is the fact that they've laid out the federal preemption argument, which is probably going to be one of the main arguments that we would make as employers and insurers, to say that we can't be responsible or ordered to pay for or reimburse medical marijuana. And that argument is basically that under the federal law, medical marijuana is a type 1 or a class 1 drug that is illegal and has been as that. If we are forced to pay for it, then we are either violating that law or aiding and abetting someone to commit a crime. And this case specifically dealt with those issues and argued those issues. What's interesting about this case, this main case, is the fact pattern. I think that a lot of cases that you will see early on that get litigated are going to be fact patterns like this, where you have a situation where you have a gentleman who had a severe back injury, had been living with chronic pain for years, had been on opioids for years and had side effects and had to go off the opioids, and was utilizing medical marijuana for pain relief. In that situation, he was also permanently and totally disabled, so he wasn't working, so you didn't have that complication. And he asked his employer through the workers' compensation system to reimburse him for his medical marijuana. The court went through the whole dichotomy of the federal versus the state law. In the state of Maine, not only is medical marijuana legal, but marijuana itself is legal. So that was not an issue, but the court did take a significant exception to forcing an employer and insurer to pay for or reimburse for medical marijuana, which was illegal under the federal law. They basically stated that to do so would be forcing the employer and insurer to become an aider and abetter under the federal law, basically committing a crime for reimbursement. The dissent, of course, disagreed, and what always comes back, and I'm sure under any workers' compensation statute, is that you really are trying to do what's best for the injured worker, and they felt that prohibiting reimbursement for medical marijuana was really not in the best interest of this particular employee, who was sympathetic and fit under the criteria that we would think of for why we would want medical marijuana to be utilized.
So as far as Pennsylvania is concerned, I think one of the most important things to remember is that we're dealing with new issues under old law. Act 44 was passed in 1993. The medical cost containment regulations were passed in 1995, and they haven't really changed a whole lot since. So we're trying to fit this really new issue, this new consideration into frankly now a little bit outdated regulations that don't address this kind of scenario. So what that means is you're probably going to see utilization review when it comes to medical marijuana. That's going to be one of the biggest places it comes up. From the claimant's perspective, petitions to review medical billing is where you're going to see it. There's been some discussion about fee review and whether we're going to see medical marijuana in the context of fee review. Personally, I don't think so, and that's for a couple different reasons. The first is that under the Medical Marijuana Act, it specifically says that a carrier will never have to directly pay a provider for medical marijuana. Well, we know that in fee review, the parties are the carrier and the provider. So the only mechanism that could actually exist in that forum is to pay the provider directly. It's not going to happen if we're considering the language of the Medical Marijuana Act. Additionally, if a dispensary filed a fee review, immediately you would raise the issue that we don't have to directly pay them, and then it's outside the jurisdiction of fee review. It's beyond the issue of amount and timeliness. So for those reasons, I don't think we'll see fee review. Now, with utilization review, what I can tell you is the most recent information we have is that the Bureau of Workers' Compensation has processed 3 utilization reviews dealing with medical marijuana. Each of them have been found unreasonable and unnecessary, and that doesn't necessarily mean there's a trend or a broader reason for that. It's just in those cases, they weren't found to be reasonable and necessary. So I don't think it sets any precedent. It doesn't, there's not a lot of lessons to be had from that. Finally, on the petitions to review medical billing, likely that's going to be the scenario you see from Claimants Counsel, and the reason is what we just talked about in fee review. There can't be payment directly to the provider, to the dispensary. So the workaround is reimbursement to the claimant, and that would be the petition they use to seek the reimbursement after they've gone to the dispensary and paid cash for the medical marijuana. So those are really the highlights in Pennsylvania that I think you're going to see this come up the most.
Is anybody in an active dispute on medical marijuana now? Probably yes. Is everybody just waiting for the first claim to come across? Okay, most of the heads are not waiting for